It's November, and that got me thinking that I should remind all of you that your assignment and the presentations are in 2 weeks from today. So just keep that date in mind. I know it's hard to see it on the board, but today we're just marching on, and we're going to cover property law. We're going to do personal property, we're going to do real property, and we're going to do landlord and tenant law. So that sounds awfully exciting, I'm sure. All right, so let's get started. So when we think about property, right, we think about property coming in, well, from a legal perspective, coming in two forms: personal property and real property. And the descriptions or the legal definitions are rather simple. I'll start with real property. Real property, the next chapter is about land, it's about buildings, it's anything that is fixed, permanently fixed to buildings. That's all real property. And then when you ask me what is personal property, it's everything else, right? So, you know, personal property is everything that is not real property. It can be both tangible and intangible property, right? So tangible are things you can touch and feel. Intangible, of course, from a business perspective, are property that you may not necessarily be able to touch and feel, can't be reduced to its physical form, but we all know things like intellectual property, for example, is an important piece of intangible personal property that has a lot of value. You will talk about fixtures in a minute. Fixtures we often think about as being more in the real property area, things that kind of start off maybe as personal property. For example, if you buy a heater unit perhaps at Home Depot, it's personal property, but you permanently install it in an apartment building, well, you know, it kind of goes with the building, it's part of that real property. So fixtures are one of those things, start off as personal property and become real property. Then, you know, each of these chapters, chapter 47 and chapter 48, talk about, okay, so now we know what personal property is. You know, we're really thinking about, from a legal perspective, how do you get ownership, how do you get legal title to personal property? And we sort of just go through obvious ways, and then we kind of hint to things that we're going to talk about in more detail. So, you know, when you think about owning, for example, real property, you know, to buy a house, to buy a building, to buy a farm, you know, to buy undeveloped property, there's a lot of formality involved in buying real property because state law regulates how, you know, how the sale is supposed to happen, what agents can do or cannot do, what kind of mortgage laws apply, how the property has to be registered or recorded, and so on and so forth. So we'll see, there's a lot of formality that goes along with ownership of real property. But when it comes to owning personal property, there's far less formality in terms of how you get ownership of personal property. And we know that. I mean, personal property is everything, right? I mean, if we're going to go buy, maybe car is one of those examples where there's still some formality, automobiles and things like that. But other things, you know, you could make huge purchases of equipment. You could make purchases of electronics and so on, and there isn't any requirement to register that or anything like that. So how do you legally acquire ownership of personal property? Well, we just go through a list of various ways, rather obvious ways. Well, you can get it by, I love this, possession or capture, right? It almost feels like we're in the wild, wild west and we're going to go, you know. No, what we really mean by this is to acquire ownership in unowned personal property. And you might say, well, there's something out there for free. Well, there might be. I mean, examples that come to mind are things like, you know, if you get, not things I do, but if you get like a hunting license or something like that, and you go hunting legally on land, and you are able to hunt an animal, or you go fishing and so on. So that's a way of acquiring ownership of personal property that was unowned, but you acquired legally. So yeah, capture, possession is one way of legally getting ownership of personal property. Yeah, but what's the obvious way? You buy it, right? You purchase it. You know, the law still kind of is written with formality to acquire title to personal property from its owner. I don't know, when I go buy something, when I go buy a computer, do I get a title to it? When I go buy, you know, I'm going to go shopping later in the day for some furniture, I might even find what I'm looking for. I doubt I'm going to get title to a new couch or something like that, right? So don't take title literally. right? That's sort of just to say you acquire legal ownership. That's all it means, right? I mean, I know that title still comes along with certain things like a car or a boat or things like that, but you know, that's not really what we're talking about. Yes, you get legal title by legally purchasing, right? Entering into a contract for the sale of goods. I will buy the sofa for this amount of money and you sell it to me, I get a sales receipt, and you know, that's a purchase of personal property. How else might you get personal property? By production. What does that mean? To acquire ownership by producing a finished product, right? So it is possible, I said furniture earlier, it is possible that I could be quite handy. I could be, right? I might actually be going to Home Depot and buying lumber and making my own bookcase, right? So I have basically acquired title to personal property by producing it myself. I took raw materials, me, can you imagine, and built a whole piece of furniture. So yeah, it is possible that, you know, we always think about acquisition as always being through purchase, but there are other means of getting legal title or legal ownership of personal property. Well, here's my favorite, right? You don't have to buy it, someone actually gives it to you, right? So it is possible to get legal title to personal property by a gift. And you know, this is where sort of people give me a look. Well, you said you weren't going to really talk about gifts. You know, gifts came up when we were talking about contracts. It's not that we weren't going to talk about gifts. The reason we kept sort of saying, oh, but a gift is different. Well, a gift, recall, cannot be a contract, right? Does anyone remember why a gift cannot be a real contract when you think back to the 4 elements of a contract? What's missing when someone makes a gift to another party? What element of a contract is missing? Does anyone recall? I know it's not going to be on the final exam, but remember? What are the 4 elements? What's missing?
You're not promised to give anything back to them?
Right, and what is that called? Oh, so close. Consideration. Right? Consideration is missing. That's the only reason why a gift fails to be a contract. But a gift, by the way, is still a legal transaction. It may not be a contract, but it is still a legal transaction. What is it? Well, as if I have to define what a gift is, right? It's a voluntary transfer, right? Someone voluntarily transfers something of title to property, ownership of property, without, the word was right there, without payment of consideration by the donee. Here we go again with our names of naming people, right? Donor is a party that makes a gift. Donee is a party who actually receives a gift. And in order to have a gift that the law will enforce, you need a few things. For example, you need what is referred to as donative intent. What does that mean? The intention to give something for nothing, you know, the voluntary transfer. What else do you need? You need physical or constructive delivery. Now, we can spend hours talking about this stuff. All this means is giving somebody something. Could be, here you go, right? It's yours, here's a ring, here's, you know, whatever. Or that's physical delivery, or it could be what's referred to as constructive delivery. What if what I'm giving to you is bulky, is big, or I don't have it with me right now, but I still want to give it to you? How else could I give it to you? Well, I could give you constructive delivery, meaning I could give you the keys to the garage where my boat is stored so that you can, you know, have it, right? So delivery doesn't have to be that I have to deliver the actual item. I could give you the means to go ahead and get that item yourself. And then the other required element for a gift is acceptance. The other party has to accept it. Most times the law will assume that reasonable people will agree to receive something that is given to them for free, right, under most circumstances, and that makes sense. So yeah, I mean, a gift is a valid way to transfer possession, ownership of personal property from one party to another. I wish we could leave it there, but we can't, because we actually have to talk about 2 different types of gifts, and a little bit of Latin comes in here. Believe it or not, there are 2 types of gifts. There's the obvious one that we always think about, which is the gift inter vivos, which just means that the gift was made during a person's lifetime. So this is your other, a parent giving a gift to a child, a friend, or someone give money to charity, right? That's a gift during their lifetime. I have tremendous wealth. I really want, I feel very strongly about a particular charitable cause, and I want to make a gift. I'm not leaving, in my will. I'm actually making a $10,000 gift. I have donative intent. I've sent the check, and the charity happily is accepting. That's a gift inter vivos, right? So, what is a gift causa mortis? That is a very particular type of a gift. It doesn't happen a whole lot, but it actually comes up in the area of trusts and estates. And by the way, we will talk a little bit about wills and trusts and estates in the next class. So gift causa mortis is a gift that is made in contemplation of death. Well, that sounds pretty morbid on a Saturday morning. Contemplation of death. So, most of us don't contemplate death, I hope, for the most part, but life is not forever, and it may very well be that someone expects not to live very long for probably health reasons, right? And you want to make a gift in anticipation of what you think would be the end of your life. And this typically happens when there is no time to go and either write a will or amend a will or things like that. So here the donor makes a gift in anticipation of what they think might be approaching death. Now, nobody can predict that, but circumstances sometimes lead one to believe that that's what's going to happen. And the gift is complete if the donor dies without having revoked the gift. So, the book gives an example. Someone, gets pretty sick or whatever and is in the hospital and really felt that they needed to do something. And says, you know what, I don't think I'm going to make it. If I don't make it, I really want this piece of property to go to, it's all witnessed, it's all whatever, they give constructive delivery or actual delivery or whatever, and there's acceptance. If you look back to the previous slide, you would say, well, the gift should be complete because there's donative intent, there's delivery, there's acceptance. However, this is a gift causa mortis. In order for this gift to be completed, the donor actually has to pass away. If the individual, surprisingly, lives after the surgery and crisis averted, there is no valid gift. And you'd be surprised. You're like, well, why are we talking about this? There's case law on this. Lots of interesting case law, which I don't think is included in this particular edition of the book. Of was this a gift inter vivos or was this a gift causa mortis? Because if it was a gift causa mortis, well, you can't have a completed gift. In other words, a donor can revoke and say, well, wait a minute. If I'm not going to donate. I'm not going to give a gift of something if I knew I was going to live on, right? So again, it's a special circumstance. Doesn't happen a whole lot. Really, it's a gift inter vivos, which is your run-of-the-mill. People decide to make a gift during their lifetime. They're not, often making a gift in contemplation of death.
Professor, but what if the need doesn't want to accept the gift? But the donor is already with that. So what's happening to the gift?
What if the donee doesn't want to accept for whatever reason?
Yeah.
Yeah, and you might say, well, why would you? You may want to for tax reasons. It may not be beneficial to you, or for whatever reason. So, if I'm understanding your question, the question is: a gift was made, gift causa mortis in your example. The donor dies, and the donee wants to reject the gift. I think you legally could still reject the gift.
But what's happening to the gift?
Well, or what happens if the donee rejects it? What happens to that property? Well, oftentimes, and this is what we're going to talk about in next class, what happens if someone dies? What happens to their property? If it's not linked to somebody, well, that's when you look to see, is there a will? If there's no will, then the intestacy laws will get to that, will determine who gets it. So there is a legal order in which property is distributed. And so it's a good question. I promise there will be details on it. Sure. All right. Again, today's chapter is really understanding personal property and how you acquire legal title to personal property. Just be aware, not something that I think is particularly important, but Gifts to Minors Acts. It's sort of interesting both from a trust and estate perspective, but also to make a gift. Oftentimes, you're not making a gift to adults. You may be making a gift to a child. And remember, anyone who is a minor is under the age of 18, as we've already learned. So there are procedures by which, if you can't make a contract, right, you also probably don't have the legal right to own the property that you can control under the age of 18. So there are laws that deal with transfers to minors. That's beyond our scope, but that's just something to sort of just know about. Accession is sort of this increase in the value of personal property as it is improved on by natural or manufactured means. So, it's kind of like, the example I gave a few minutes ago about production. Well, it's possible that I might own a piece of personal property, but I improve it, right? So I could own an older car, but it's a terrific car, and instead of getting a new car, I actually get a new engine, I get new spoilers or things like that, that I actually increase the value of that personal property by simply improving it. So all of these are simple examples of legally owning new pieces of personal property, right? The last example is not all that significant. This is the example with commingling of fungible goods. What is a fungible good? Fungible things are things that are just like everything else. So like, for example, if I were to have 50 copies of this textbook, they'll all be the same, right? It doesn't matter if I pick up this one or that one. And the book gave an example of let's say there were a few farmers that decided that they wanted to store their grain for the winter, and they bought the storage facility, and each of them paid the storage fees, and they put 50 kilos of grain, and then the winter season was over and they went to sell the grain. How would they divide up the property? Well, you can't really, my grain, your grain. Grain is grain, right? It's 50 times 3 is 150. You go to market and you sell it, you would get the proceeds from it, you would divide it up. So I don't quite understand what the real significance. I guess the point that they're trying to make here is that when goods are essentially exactly the same, ownership interests are, in the entire set of goods, you get in proportion to your ownership interests. So for what it's worth, that's what's there. All right, so this kind of goes back to this notion of how else can you get legal ownership of personal property, or even real property for that matter. Well, you could get a gift during someone's lifetime or in anticipation of their death, or you could inherit something, right? That's another legal way of coming into personal property. And again, as I said, we'll talk about wills and inheritances and trusts and so on, all in the next chapter. Suffice it to say here, yes, that is one way in which personal or even real property can be transferred. We will also, believe it or not, this version of the textbook also has a chapter on family law. So we will, at the very end of this semester, talk about family law and matrimonial law. That gets people interested. It's sort of a topic people can easily relate to. But yes, it's possible to get personal property given to you as a result of a divorce or an annulment, right? And you might say, well, you might have owned it to begin with. Well, maybe, maybe not. This is an example of how property could be jointly owned and then divvied up by a court, if in a settlement or something like that, where you get, interest in that property individually. So yeah, divorce and annulments are ways in which parties can get rights in personal property as well. All right, how else? Well, what about property that might be lost, abandoned, mislaid? How do we determine who the owner is, who gets rights to that property? Again, there are all kinds of interesting cases in this area and so on. All we're really doing here is getting a summary view of how laws over the years have evolved. So, believe it or not, there is a bit of a difference between how property is characterized in terms of who has legal ownership of that property. And you have to look to see, well, was the property mislaid versus lost versus abandoned? And you might say they all kind of sound like the same thing. But they're not, because legal disputes arise and they're settled differently based on these characteristics. So what about mislaid property? Well, mislaid property is property that the owner kind of left somewhere voluntarily, and then just forgot about it, right? So, for example, and the book had a good example, someone goes to a hotel, and who hasn't like lost things or forgotten things at a hotel, right? I mean, you're there, you put things in a drawer, you've got, you treat it as your home, you're there for a few days and you leave, and you've left behind something, right? Who does the property belong to? Did you mean to leave it there? Was it really lost? No, it was mislaid. You inadvertently left it somewhere. And let me just make sure that the answer is not on the next slide. No, okay. So the rule with mislaid property typically is that the true owner has claim to that property, right? So if a week from now, 2 weeks from now, you say, well, hey, and assuming this is an honest world and everyone sort of does the right thing, the true owner will definitely have the legal title to that property. So this is not where, the next guest comes in. You might argue, well, finders keepers, losers sweepers. No, that's not how the law works. No, the next guest doesn't have true rights to that property. What they should do legally is turn it over to the hotel, and the hotel doesn't have legal right to that property. The hotel keeps it for a period of time until the true owner comes forward, and if they don't, maybe they do get to keep it under state law or whatever. But the point here is that this is mislaid property. It actually belongs to the true owner, assuming that they ever claim and come forward to get it. What about lost property? Well, lost property is, lost means lost, right? Somebody leaves it somewhere due to carelessness, negligence, or whatever, drops something, and who hasn't done that, right? And again, the question is, well, who does that property belong to? What do you think the answer is? The person. Right. Well, the person who lost it, right? The true owner, right? But until that, you may not even know where you dropped something. What if you're just walking down the street or something like that, or you were on a bus or a subway or New Jersey Transit or whatever the case might be, right? Who does it belong to? Well, again, assuming a perfect world where everyone does things the right way, it's not the next person that takes a seat on that train. It actually belongs for safekeeping by New Jersey Transit in their lost and found department to be claimed by the true owner. And after that, states have different laws. I mean, it may just, what they call cheat to the state or sort of be used for state purposes or whatever, right? I mean, if the true owner doesn't claim it, it's one thing, but otherwise it belongs to that individual. It doesn't belong to the next person. And then the law draws a distinction with abandoned property, right? Not mislaid, not lost, but abandoned. So when you abandon something, you don't want it anymore, right? I mean, that's typically the notion there, right? Property that someone throws away, discards with the intent of not wanting it anymore, right? So mislaid or lost property that the owner has given up any further attempts to locate, that is abandoned property. And abandoned property is something that the finder could keep, realistically. And the next case was a case that was sort of interesting because it turned on whether or not property was abandoned, because in that case, the finder could keep it, or was it mislaid, in which case the true owner would have rights to it. And this was the Grant versus Jennings case from Arizona a few years ago. And what was at issue here? A lot of money, $500,000, right? So somebody real quickly tell me what happened in this case. Perhaps somebody who hasn't spoken today. Yes.
I think they, if I remember, it was a couple who bought a house, and they found money within the walls.
But tell me what happened before.
Oh, I think there was a construction or something.
Well, there's even more. Think back to who was the owner of the house originally? Can I fill in those details?
Yeah,
for you
go
real
ahead,
quickly?
yeah.
So what happened here was an older gentleman lived in the house, and I guess he didn't believe in the banks and so on, so he used to hide money all over the house. So when he passed away, his two daughters, who actually inherited the property, went and looked, and they found all kinds of money and rare coins. I think this was an Army veteran or something, and found a good amount of money, what they expected their dad to have been doing all these years. And after they thought that they found everything, they put the house up for sale. And now, pick up with the story.
Yeah, and then that's where, was Jennings and McCollum?
Oh, forget the names, let's just call them.
They bought the house, put the wasn't there construction before, and then they.
I forget the order, but I think the way,
And they did, I think the construction workers did see
it was after the sale of the
was it
house.
after the sale of the
Yeah.
house? And, I guess they went to court, and it was it mislaid or abandoned, but there was no, answer if it was abandoned, so I think it went to the owner, not the owner, the person who owned the 500,000 instead of the owners.
Right, but the person, so yeah, so I mean, I think you got, the facts are a little bit confusing
Yeah.
because they sort of threw in a contractor in the middle too. So the real issue here was, okay, so the individual passed away, his daughters found a bunch of money which they expected, they thought that they had cleaned the house of all the valuables, put it up for sale, the new owners hired a contractor, the contractor's people actually found the money. The first issue was they kept it, but then it came to light, one of the workers spoke up, and the contractor had to actually give the money to the new owners. Now, the new owners wanted to keep it. And saying, hey, we bought the house, as was, and we're gonna say that this property was left there abandoned, it belongs to us as finders. But the daughters of the individual who owned the house, I mean, it's their house now, said, no, this was mislaid property. We are the true owners. We deserve the $500,000. And the court said, look, we have to decide whether property was abandoned or mislaid. And the court said, do you abandon the $500,000? Does anyone ever abandon money? No, no reasonable person does that. So here, it really did belong to them. They just weren't, it was inside some, it was in a wall, like they had to demo a wall in order to actually find it. So I'm telling you, the guy was hiding money in the house all over the place, in pipes and in things like, out there. So the court actually awarded the $500,000 to the original owner's kids under the premise that this was mislaid property, not abandoned property. So, if you're angry at me for going over these definitions, understand some cases turn on the definition of whether something was actually mislaid, lost, or abandoned property, because it makes a difference on who actually gets the property. All right, we can go on and on about personal property, but we're actually going to switch gears a little bit and talk about the concept of bailment, right? Bailment is a big part of this chapter. And what is a bailment? Well, you know what the first thing a bailment is? It's a contract. It's an agreement, right? So, just because we're done talking about contract law doesn't mean that contract law doesn't sort of seep into just about all the various aspects of things that we talk about. So, what exactly is a bailment? Well, a bailment is a transaction in which an owner of personal property, you'll see in a minute, transfers his or her personal property to someone else to either be held, stored, delivered, or for some other purpose. So the one thing that, so you're basically one party is giving personal property to another party, but they're not giving title, they're not giving ownership, right? So they're not relinquishing their ownership interest. All they're doing is they're giving it for a particular purpose. And we'll see that purpose could be you want property to be stored by somebody, held by somebody, delivered, any of those reasons. And by the way, you and I enter into bailment agreements all the time without even realizing. I mean, who doesn't go to the dry cleaners, right? Who doesn't sometimes go to a nice restaurant and have their coat be checked? Who doesn't sometimes valet their vehicle? What is all that if not a bailment, really? And really what we're talking about here is liability, right? Because from a legal perspective, we know that things go wrong. And what are the rights and responsibilities, for example, in a bailment situation? So the first thing is, look, title of the property does not transfer because bailment is not changing ownership, right? It is just someone holding property for some period of time. And once again, we can't talk about a new area of the law without naming the parties, right? Bailor, bailee, right? So what are we talking about here? Bailor is the owner of the property in a bailment. So let me just make it very simple. If I go to the dry cleaner with my, laundry, I'm the bailor, okay? And the holder of the goods, who is not a seller or a buyer, the dry cleaner is just gonna, hopefully clean those clothes, is the bailee, okay? I am the bailor. The dry cleaner is the bailee.
Now, I want to ask you.
Sure.
Is there any difference between bailment and keeping
Oh, so the question is there a difference between a bailment situation and a consignment sale? Well, I would say that a consignment is sort of a type of a bailment, because the purpose there, everyone know what a consignment is, right? When, I don't know, I'll give the example of like, maybe you have something in mind, but you know, sometimes you go to a place because you know you make jewelry and the shop could sell your jewelry, so you know it's a jewelry shop and they put your jewelry up with their stuff, right? Is that what you had in mind? Yeah, that's a bailment situation. You have it there because if they sell it, you'll get a profit out of that or something like that. Yeah, yeah, that's a type of a bailment. Consignment is a type of a bailment. Okay, so the real issue here is what if something goes wrong, right? What if the store burnt down? Heaven forbid, what happens to your jewelry? The real issue here is understanding liability of bailors and bailees, and we already know what this is, right? A bailor, bailee, someone is handing over personal property to a bailee for some particular reason. Before we get into that, what are the required elements of a bailment? Well, for one thing, bailment is only for personal property. We're going to talk about real property in the next chapter. It is true that real property sometimes is transferred to another party without being sold. That's called a lease of real property, right? We have a whole chapter on that. It's not called legally a bailment. So a bailment can only be for personal property. And in order for a bailment to happen, you have to give the bailee possession. You have to literally give the personal property over to the bailee. So the bailee must have exclusive control of the property and must knowingly accept the property. You know, anyone ever been to a parking garage where you sort of see this big sign? Sometimes it says, this does not constitute a bailment, you know? Because what they're saying is, look, we're not responsible. We're providing you with this parking lot. You know, you're more than welcome to park here and pay our prices and blah, 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 but we don't have security guards. We don't know, may not be the best neighborhood. And if something happens to your car, we are not taking control over your vehicle. We have not so they're basically telling you, not a bailment, something else, because in a bailment, as we'll see, the bailee takes responsibility, some level of responsibility. And, parking garages don't want to do that ordinarily because, for $10 to park there, they're not going to be liable for, $500 worth of damage to your car. That's just not what they're bargaining for. And you need an agreement. Right? Remember I said a bailment is really a contract, right? And it could be an express or implied agreement, meaning, you don't need formality. It's not subject to the statute of frauds. I mean, when I go to my dry cleaner, I don't expect to write out a 3-page contract over the 3 pieces of shirts I'm giving the poor guy, right? But it is an agreement that I kind of expect my laundry back. I kind of expect it back in reasonable shape or whatever, and I kind of expect it back clean. Right? So, yeah, I mean, those are the elements of a bailment, only involving personal property, the bailee agreeing to take possession of that property, and an agreement to do whatever it is. If it's a consignment, that they'll take good care of it, that they'll agree to put it up, that they will agree to sell whatever it is that you are leaving there. Oh gosh, okay, so there was a case in the book about, let me just do this case real quickly. This is the car wash case. And this is sort of an interesting case. This is, who in their right mind? But anyway, this involved a jewelry salesman, right? A salesman that went all over the place showing expensive jewelry on the road. Smart guy, I guess, in that he at least had the jewelry locked up in a safe in the trunk of his car. How much jewelry was in the car on this particular day? 850,000. It's funny how we remember those numbers, right? What did this guy decide to do? Oh, I think my car looks kind of dirty. Let me go to the car wash. I don't know about you. If I had $1 million worth of jewelry in my car, I would want to I would be so neurotic. But goes to the car wash. And, so what happens here is that, if you've been in a car wash, you have to kind of give the keys and they're kind of spiffing out your car. And the car wash didn't do anything wrong. They had this procedure when the car was ready, they would signal and you would go over and you would say, oh great, and then you would drive away. Well, things didn't kind of turn out that way here. Because, I don't know exactly what happened here, but what I think might have happened here is that someone knew that there was expensive jewelry in the car. They probably followed the guy. And as soon as they saw the opportunity that the car was unattended, as soon as the car was ready, they drove off with the car. And he's like, oh my God, you call the police, and guess what? Within 15 or 20 minutes, the car was found. But the thieves were able to hack into the trunk, they were able to get the jewelry gone. Okay, horrible. Let's hope there was insurance. But what does the jewelry store do? They actually sued the car wash because it was a bailment, they argue, and you did not properly take care of the car. And what does the court say? By the way, it went all the way up to the Supreme Court of Alabama in 2004. What did the court say? Was this?
There was no bad.
And even if, look, even if you could argue that there was a duty of care, the duty of care was, I recently went to a car wash, and after I was done, I noticed that my rear view mirror was cracked, okay? They saw that, they acknowledged, and they said, we're really sorry. We will tell you a place to go to, they will replace it, right? That's fine, that's, one doesn't go to a car wash and expect their rear view mirror to be, not my rear view, my side mirror, all right? That's a different story, that amount of reasonable, but, they have a process in place. They're not going to have 6 guys with machine guns holding, safeguarding you. No, they're just going to go, it's ready. Go get it, right? And if in that interim something happens, a car wash is not responsible. The court said, no way, you're out of luck,
But they leave the keys in the car.
It's not
you have to kind of handle it to the owner of the car. It's not right.
So you're arguing that car washes don't have the best procedures, maybe. And that's a different story. And that really goes to negligence versus ordinary care. But most courts and most reasonable parties would say, look, it's a huge operation. You don't expect, unless it's a reasonably decent neighborhood, you don't expect people to be standing watch and saying, we're going to jump that car and steal it. It's just so infrequent, it's so hard to imagine that would happen, that I, on the other side, would argue, that's kind of reasonable. In those kind of neighborhoods, people sometimes walk into a drugstore to go get something and leave the keys in the car, right? So why would we hold the car wash responsible? But that's really the issue. What is reasonable care, right? And that's kind of where we're heading. So, bailments. Well, you've got a bailor and you've got a bailee. And so far, the examples that I've given you, car washes and dry cleaners and valet parking, are really examples of, let me just go to the next slide, of a mutual bailment, right? And a mutual bailment or mutual benefit bailment is a bailment for the mutual benefit of the bailor and the bailee, meaning both parties are doing this for their own benefit, right? So, when I go to a car wash, I want a clean car. When somebody agrees to do that service for me for $15, $20, it's a business. They're looking to make money. So the question is, what kind of a duty do they owe me? Well, they owe me a duty of reasonable or ordinary care, which means what? That the bailee will not be ordinarily negligent in caring for the bailed goods. And the reason I kind of skipped ahead to that is I want to go back to your question, which is, well, is leaving the car keys in the vehicle or, be going beyond ordinary negligence? Most courts would say no. If it's a really terrible neighborhood, possibly, but if it's a nice suburban neighborhood, nothing ever happens, there are no thieves looking to whatever, I would say that that's kind of okay. They're doing their job. But it is ordinary negligence for my side view mirror to be cracked. It was perfectly fine, and it wasn't, and believe me, they didn't even give me a hard time or whatever. They said, don't worry, we will take care of it, right? Because those are the kinds of things that they anticipate sometimes happening, right? So that is a typical bailment situation where you say the bailee owes the other party a duty of ordinary care. Let me go back. But you could have other kinds of bailment where the duty that the bailor or the bailee owes is a little bit different. For example, bailments for the sole benefit of the bailor, meaning it's not a mutual kind of a situation. This is a bailment where the only party that is benefited is the bailor. Who's the bailor? the owner of the personal property. So let me think of an example. Okay. The example is that neighbors, and one neighbor is going away on vacation and asks their neighbor, you know, I'm going to be gone over the weekend. Could you please take care of my dog? And the neighbor has been looking, you know, sort of, you know, their friends or whatever, and the dog often runs free, you know, the dog knows to come back home, and basically, sure, we'll feed the dog, we'll take care, you know, if he gets sick or whatever, we'll take him to the vet, and things like that, right? So here, this is what's called a gratuitous bailment, meaning the bailee is not getting anything out of it, the bailee is just being a nice person, right? And doing what they've seen their owner or their neighbor do for the dog, you know, whatever. So the duty that is owed is a duty of slight care. Just don't be grossly negligent, but you know, you don't have to go over and beyond. So here, if the dog runs away, never comes back, you know, and what if the dog was like this prized show dog or something like that? You know, are you going to be able to sue your neighbor for not exercising the level of care that they should have as the bailee? First of all, was there a bailment? I would say yeah, right? Personal property. I would say agreement, and I would say knowingly accepting. But the bailment was for the sole benefit of the bailor, right? The bailee didn't get anything out of it. It was a duty of slight care. Were they grossly negligent? No, they fed the dog. They did everything that they possibly could. I mean, you know, what if the dog just got depressed that he or she was abandoned, or something happened and they, you know, so, I mean, that's not some, you know, this person didn't do anything differently that the owner was doing. So that is a very low duty of care. Now let me switch it around a little bit. Bailment for the sole benefit of the bailee. So here, the only person that is benefiting is the person to whom the property is given. So let me go back to the neighbor example, and the book had this example of a lawnmower, right? You know, your neighbor wants to borrow your lawnmower, and they don't want to buy their own. They ask you permission. Could we use it? And you say, all right, well, whatever. Sure, you can, but please be careful, right? So, you know, they're very, very careful. Blah blah blah. But you know, you get a phone call. You go inside the house to answer the phone call. You leave the lawnmower there running. Come back, it's gone. All right. What is the duty of care? Well, here it's a duty of great care. If it's for the sole benefit of the bailee, the duty owed by the bailee is not even to be slightly negligent in caring for those goods, right? So here, in this case, one would argue that that amounts to a lack of high care, right? Should have not left it unattended. And you know, if I change the facts here a little bit, and what if your neighbor asks to use your lawnmower but is willing to pay you for it, right? Now it's no longer for the sole benefit of the bailee. It really is a mutual bailment, and now the level of care differs. So, I mean, again, there is case law on bailments to see, you know, who was this bailment benefiting, and based on that, under the circumstances, did the person exercise, you know, the level of care that was required under those circumstances, okay? CPA exam loves bailments, you know, so understand the basics of what a bailment is, what are the three varieties it comes in, who is a bailor, who is a bailee, that sort of thing. How long do bailments last? Well, it's up to, didn't I say it was a contract, and a contract is a voluntary agreement, right? So it could be for a short period of time, I mean, you know, or it could be as long as you want it to last, right? I mean, if you're storing your goods somewhere as a business, right? And you're paying them on a monthly basis, but you don't know how long you're going to store it there, that is a bailment at will, that the parties don't have a fixed term. But most bailments are for a short period of time, right? If I'm leaving my car somewhere, it's not forever. I mean, you know, I expect to get it back. If I'm going to the dry cleaners, it's really for a fixed term. I'm going to come pick it up on Tuesday night or whatever, right? So bailment, it depends. It depends on what we're talking about in terms of how long the bailments last. Now, real quickly, we're just going to look at a few special situations that raise bailments. For example, a warehouse company, right? What do warehouses do? They store things, right? They hold things. That's their entire business. They're like these big, huge places that are just storage facilities, right? But they do it for money, right? We will store things, but we will get paid by the bailor for the privilege of leaving things there, right? What kind of a duty do they owe? Well, what kind of a bailment is it? It's a mutual bailment, right? Somebody pays a price to store their goods, and so they're going to owe a duty of reasonable care, right? And typically, you know, the bailment company is going to have paperwork, right? They're basically going to say, we'll take these goods, and here's a receipt by which you can come and claim those goods, right? I mean, that's how warehouses work, and it's a special type of a bailment. Okay, another type that we think about is, remember we said a bailment can happen when you're actually trying to deliver goods, right? So what is FedEx? What is DHL? And all of that is not a bailment situation, right? Because aren't they acting as a courier, a common carrier to carry goods from one place to another? That's their entire operation, right? So again, you look at that as a mutual benefit bailment because they're getting paid and the bailor gets the benefit of having their goods transported, right? So here, let me not get into, obviously we can consignments and so on and so forth, but let's just leave it, let's not name parties too much. But common carriers are companies that offer transportation services to the public, right? They're acting as bailees. So back in the day, the liability was strict liability. Remember what strict liability was? Strict liability is liability without fault. So basically, if something happened during transportation, meaning if the bailed goods were lost, damaged, destroyed, stolen, the common carrier was liable even if it wasn't their fault. Now, you can imagine that this is a really good thing for you and I, but it's not a fantastic thing for the company because, who knows how much property was worth that was being transported, and if they're going to be strictly liable for replacing that, that would be a huge issue, right? So over the years, what the law has allowed, remember, it goes back to understanding that bailments are contracts. So if it's a contract, that means that parties can negotiate the terms. So what happens now is, forget about bills of lading, we'll come back to those later in the semester or next semester, but what common carriers have started to do is they now basically tell you, it'll be on the receipt, it'll be on their on the paperwork that they hand you back, is we are only responsible up to $1. Yes, we're liable if I give you a receipt and the other party never receives it and we don't have any proof that it was ever delivered, we are responsible for a package of this size for up to $100, right? Now, what if you're actually sending over things that are worth much more than $100? They'll allow you the ability to buy more insurance because they know that it's highly unlikely that goods won't get there, but it is possible, right? So they're not going to guarantee loss of more than that, but if someone wants to say, well, wait a minute, what I'm sending over is, what is a Christmas gift that's worth, $5,000, I want to buy more insurance, they'll say, all right, then you have to pay more in insurance to safeguard that risk. Right? So it's a contractual agreement. So yes, there is strict liability, but strict liability only up to a certain dollar amount. You want to negotiate terms that are more favorable, and businesses often do. You're going to have to pay for that added security or for that added protection. Doesn't tell us much. It just basically tells us that a bail or bailee situation exists in a common carrier situation. The next case was, it's sort of a common carrier case, right? I'll do this one real quickly too. This was a FedEx case where, you go to a post office, you go to UPS, you go to any of these places, they say, are you carrying any are there any, usually they want to know if there's something flammable or, they're concerned about safety risk, and oftentimes they will also say, are you transporting money or currency or things like that? They don't want people to send money. Literal money, I don't mean a check, but so here someone didn't say anything, they basically sent rare collector coins through FedEx and the package gets lost. And now they want FedEx to pay the value of those coins, and FedEx says no, we won't, we're not liable. And the court actually agrees with them, rightfully, and this was just a trial court, federal district trial court that basically says, no, this is, well, they said two things. One, it was prohibited to send money or currency, and coins are a form of currency. So that right there. And number two, the value was never disclosed. So FedEx is not liable. I mean, they may be liable for the minimum value of losing the package, but they're not liable for how much those coins were worth. Yes?
So if it had, like, if they had written that it was, like, the amount, would they have?
Well, I think FedEx wouldn't have done it because they are not
Because
going
it's
to
currency.
transport or send money. So someone just wanted to get it, And, people do that. They'll lie. But then you can't have it both ways. You can't, then go back and say, but what I had in here was, coins worth, $500,000. Well, too bad. The courier is not liable. And the last thing we'll talk about are innkeepers. What are innkeepers? But hotels, essentially. I mean, you can kind of see the terminology is sort of dated. And this is the notion of, well, when you sort of pay someone for spending a night or 2 nights at the hotel, and you lose something at that facility, is that facility, hotel, liable? And again, the law here used to be a strict liability. And that kind of makes no sense, right? So over time, what has happened is laws, and by the way, this is state law. States have adopted state statutes that limit hotel liability, because hotels now will tell you, we are not responsible, right? Because, again, they don't, this might be a huge resort where you've got, tons of rooms. They're not going to take the responsibility that you forgot to close your door properly and someone else went in and whatever. So they will basically say, we are not responsible for items that you bring in that could be stolen, and so on. They may provide you with a safe to keep your valuables, but even then someone could come in and pick that safe. They're not going to be responsible. They'll give you the safeguarding mechanisms, and they might even say that we will hold property for you at the front desk, but they will probably put a dollar limit on how much that can be, because again, they're in the business of providing you with a safe place to stay. They're not in the business of providing you with, armored services to guard property that is very, very valuable, right? So over time, the laws have allowed carriers and hotels and other places of accommodation to limit their liability in these types of situations, because they are bailment situations, right, where personal property is stored for a period of time, and the question is, as bailees, how far does their liability run?